we na kwaba e de Benkasa TV na ina ni konkohwe the Supreme Court Ghana na ura the majority leader in parliament ura Alexander Afenyomakins the huge injunction be akoto Supreme Court judges nim concerning sensen bia ekoso ewo Tamale Central ura Haruna Idrisu akache na so chemo setino ura Haruna Idrisu echema setino 3 NPP seats and as a 3 parliamentary seats to be declared vacant if say some of they are declaring themselves as independent candidates. There's no ura Afenyomakins echema setino aka 2 months when they are kotoaba and it's to me sanso and by election concerning these matters and it's from the Assembly could say the Assembly could tabiri Supreme Court na dia honorable Afenyomakins eka no kre na de ura Haruna Idrisu susa eka no kre na why na yemfa na asem entonchine tinanum Ghana fo monka mo ne kwetesa asem we Supreme Court na hu nsesema ekoso ohon mbra medamu ina as
members of parliament. Haruna Idrisu petition submitted to the Speaker of Parliament seek to have the parliamentary seat for Suhum, Amenfi Central and Aguna West declared vacant due to the decision of the MPs from those constituencies to contest the 2024 elections as independent candidates. Additionally, the petition called for the seat of former MP Andrew Esiama Amoakun to be declared vacant as he intends to run for re-election under the New Patriotic Party ticket, despite having originally won his seat as an independent candidate. At a leaders' media briefing, Afenyomakins emphasized the need for a clear legal pronouncement from the Supreme Court to resolve the matter, which has raised questions about the constitutional provisions governing MPs who switch political alignment or contest election as independent. He argued that a ruling from the court would bring clarity and settle the ongoing controversies surrounding the affected parliamentary seat. This case touches on Article 97, Clause 1G of Ghana's 1992 Constitution, which deals with the condition under which an MP can lose their seat, particularly if they leave the party on whose ticket they were elected or switch from being independent to joining a political party. The potential implications of this case are far-reaching. If the MPs are found to have vacated their seats, the NPP would lose its slim majority in the current parliament, potentially derailing government business in the crucial months leading up to the December 2024 election. Afenyomakins' affidavit highlights the delicate parliamentary balance at stake. You know that Ghanaian law prohibits by-election within 3 months of a general election. Consequently, if Article 97 Clause 1E is strictly interpreted, the ruling party would lose 3 MPs, reducing their numbers from 138 to 135, while the opposition remain at 137. This shift, he contends, will result in the opposition assuming majority status for the parliament final quarter, potentially altering the legislative landscape in the crucial pre-election period. Crucially, Afenyomakins has also filed for an interlocutory injunction to prevent the Speaker of Parliament from making any ruling on the MP status until the court reaches a decision. He argues that premature action could cause irreparable or irreversible damage to these MPs by having their names expunged from the roll of the 8th Parliament of the Republic of Ghana. This legal maneuver brings to the fore the complexities of Ghana political system and the challenges of interpreting constitutional provision in a rapidly evolving political landscape. It also underscores the tension between individual political aspiration and party loyalty, a recurring theme in many democracies around the world. The current constitutional crisis echoes a similar situation from November 2020, when then Speaker of Parliament, Professor Aaron Mike Okoye, declared the Formina parliamentary seat vacant, in that case, incumbent MP Andrew Amakon Esiama, who incidentally is at center of the present legal and constitutional challenge, had decided to seek re-election as an independent candidate after losing the NPP primary. Okoye's decision was based on Article 97 Clause 1G of the 1992 Constitution, the same provision now at the center of the current dispute. At the time, Okoye argued that having fortified the membership of the party on whose ticket he was elected to parliament, the operative language of the constitution is that shall, which is mandatory, vacate his seat in parliament. The president add weight to the opposition current stance. However, majority leader Afenyomakin's legal challenge seek to distinguish the present circumstances, arguing that the member of parliament decision to run as independent in the upcoming election should not affect their status in the current parliament. This Moon's interpretation set to stage for a landmark ruling that could redefine the application of Article 97 Clause 1G in Ghana's evolution political landscape. Enti Afenyomakin say ma abans man Kingsford Babin make changes there until say the Supreme Court of the land etimi eden stamp esiso ansana Afenyomakin ansana Babin etimi declare one seat in vacant, because who could declare vacant when the Supreme Court in who release any quasi a declare man, it means a fort on our course in a more than senka ubetimi a repair into this year the moon to me and fan sanka until say the Timmy Ako Supreme Court on Abba Emma Supreme Court in ruling etimi Abba Beto Abontin ABC during Michael Okoye time nanso enya de say ono etimi declare obi seat for vacant. Nti Afenyomakin say yenya abotre na akwa piem Supreme Court dey Supreme Court e de na temo eba na yetimi atoa so e de free ho.
Majority MPP MPs and one NDC MP are at risk of losing their seats with barely 2 months until the expiration of the 8th Parliament. Now, former minority leader Haruna Idrisu has signaled that his side will trigger the appropriate constitutional standing order provision to declare seats of these 4 MPs vacant, with Parliament currently constituted as 138 and 137 for NDs, for the MPP and the NDC MPs. This will mean the NDC will become the majority should they succeed in this effort. Listen to Haruna Idrisu make the point at a campaign rally.
On Tuesday, the Parliament of Ghana will reconvene. And when it reconvenes, I am very certain that Parliament and Ghana will go through a major constitutional test. And that constitutional test is that the NDC minority must become the majority from Wednesday next week. I assume, and this must happen if there is constitutional and legal propriety in Ghana. Because any nuanced interpretation of Article 97 provides that if a member of parliament on a political party ticket like NPP defects and fails to be independent, that MP ceases to be member of parliament. And if an independent member of parliament, by virtue of the provision of Article 97 subclause G, an independent joins a political party, that independent loses constitutional recognition and does not belong to parliament. And even if an NDC candidate, MP, defects to become an independent, he ceases to be a member of parliament. Therefore, we will invoke